coming home after a long day of work and discovering that your key no longer opens the door is one of the most desperate situations a tenant can face in the United States. There's no advance notice, no certified letter, no phone call warning that something is about to change. From one moment to the next, the landlord simply changes the lock and leaves the person outside their own home without any explanation, without any process, without any chance to prepare for what's happening. Inside that property are work clothes, important documents like a passport and driver's license, ongoing medications that often can't be replaced overnight, and in many cases, the few belongings a family managed to gather over years of effort. This isn't just an annoying inconvenience or a misunderstanding that gets resolved with a quick conversation. It's the concrete feeling of being treated like a trespasser inside a place that by law and by right still belongs to that person as long as the lease is in effect. This kind of situation happens far more often than most people imagine across different American states. It happens to tenants who are behind on rent, but it also happens to people who are current on all payments and simply got into a disagreement with the landlord. It happens in disputes with homeowners associations, the so-called HOAs, that try to pressure a resident into backing down on some decision. And it also happens during foreclosure proceedings, when the bank or financial institution acts before the legal deadline, believing no one will question it. What few people know is that the way someone reacts in the first few minutes after discovering the changed lock can completely determine the direction of the entire dispute. An impulsive reaction can weaken that person's legal position. A calm, informed, strategic reaction can, on the contrary, put the landlord in a much more precarious position under the law. In the heat of the moment, it's extremely common for the first reaction to be anger. The person pounds on the door, shouts the landlord's name, threatens to call the police at the top of their lungs, or even tries to force their way in however they can. It's a human reaction, almost automatic, because no one can rationally process the feeling of being locked out of their own home without any warning. The problem is that this reaction, however understandable, can turn completely against the person suffering the injustice. Many landlords, especially those acting in bad faith, are counting on exactly this kind of uncontrolled reaction. If the tenant shouts, threatens, kicks the door, or tries to break the lock, the landlord suddenly has a new narrative to tell if the situation ends up in front of a court or a mediator. Instead of the case being about a landlord who illegally changed the locks, the case becomes about an aggressive, out-of-control tenant who threatened the property or even the safety of others. Security cameras, neighbors as witnesses, and text messages sent in a moment of anger can later be used as evidence against the very person who was wronged in the first place. There's another dangerous effect of this impulsive reaction. When someone tries to force their way into a property, even if they're the tenant themselves, they run the risk of being treated as if they were trespassing, especially if the police are called before anyone checks the lease or the legal situation. This can lead to a police report, a trespassing accusation, and in more serious cases, even a temporary detention while everything gets sorted out. What should have been a quick, simple win turns into a completely unnecessary legal nightmare. The tension in that moment is real, and the feeling of injustice is entirely legitimate. After all, no one should feel like an intruder inside their own home, but that's exactly why understanding the difference between reacting with anger and reacting with strategy matters so much. The good news is that there's a far more effective path than shouting at the door, a path that real estate attorneys have recommended for years to protect tenants in exactly this kind of situation. Here's the point that completely changes how this person sees their own situation. In most U.S. states, a landlord is not legally allowed to simply change the lock and prevent the tenant from entering the property, even if the rent is late, even if there was a prior argument, even if the landlord is convinced they're right. This kind of action is called a self-help eviction, and it's considered illegal in the vast majority of U.S. jurisdictions. The logic behind this is simple to understand. The American government created a formal eviction process, specifically to prevent landlords from taking the law into their own hands. This process involves written notice, a legal period for response, and in many cases a court ruling before any actual removal takes place. When a landlord changes the lock without following this path, they are skipping steps the law considers mandatory, regardless of the reason they may have for acting that way. This means that the tenant, even if behind on rent, even after a serious disagreement with the landlord, still retains the right to access the property until a legal eviction process is properly completed. This isn't just a matter of manners or mutual respect between the parties. It's a matter of legal procedure, with real consequences for whoever breaks the law. In many states, a landlord who acts this way can be required to pay fines, compensate the tenant for damages, and even cover the cost of temporary housing if the tenant was left unable to access their own belongings. It's exactly at this moment that the person standing outside the door begins to realize something important. She is not defenseless. She is not without options. She still has concrete, legally protected rights, even while physically unable to enter her own home. And understanding this completely changes her posture. Instead of shouting and arguing, she can act in a much smarter way, a way that strengthens her position instead of weakening it. After understanding that legally protected rights still exist, the most important moment of this whole situation arrives. What to say, and especially how to say it. The most effective way to act in this moment doesn't involve shouting, doesn't involve threats, and doesn't even involve arguing at the door with the landlord. It involves one simple, calm, extremely direct sentence, said or sent in writing, that completely changes the direction of the conversation. The sentence is, "I am requesting immediate access to my residence. Please confirm in writing the legal reason for changing the lock." Notice carefully what this sentence does and doesn't do. It doesn't accuse the landlord of anything. It doesn't use an aggressive or threatening tone. It also doesn't beg or show desperation. What it does is clearly create a formal request for access to the property, while at the same time demanding that the landlord justify, in writing, the legal basis for that decision. It's a sentence that any tenant, regardless of age or experience with legal matters, can say or write without difficulty. This sentence works because it completely shifts responsibility to where it belongs. From the moment it's said, or better yet sent, by text message or email, the landlord knows that request for access is now documented with a recorded date and time. If he decides to ignore that request, that refusal is also on record. And any court, mediator, or tenant protection agency reviewing the facts afterward will clearly see who acted correctly and who refused to follow legal procedure. Even more than that, this sentence forces the landlord to put a justification in writing, something many bad faith landlords simply cannot do, because there is no legal justification for changing a lock without following the formal eviction process. By requesting that written confirmation, the tenant is, without immediately realizing it, putting the landlord in an extremely uncomfortable position. Either he admits in writing that he acted outside the law, or he stays silent, which can also later be used as evidence of improper conduct. It's interesting to notice how such a calm sentence can have a much stronger effect than any angry shout at the front door. This happens because the moment the tenant shouts, threatens, or argues, the landlord sees only uncontrolled emotion, something he knows how to handle, and which, in many cases, he can even use to his advantage later. But when the tenant shifts tone and presents a formal written request demanding legal justification, the landlord sees something completely different. He's dealing with someone who knows their rights and is documenting every step of the situation. This shift in posture completely changes the dynamic of the conflict. As long as there was only shouting and arguing, the landlord held emotional control of the scene, pressuring the tenant through intimidation. Once there's a written message with a recorded date and time, demanding a formal response, the power shifts. Now, the landlord knows that any action he takes from that point forward can be used as evidence, whether in a complaint to the city, in a lawsuit, or in a formal complaint to a tenant protection agency. Many bad faith landlords are counting precisely on the fact that most people don't know how to react strategically in this moment. They expect shouting, verbal threats, maybe even an attempt to break the lock, because that makes their narrative easier if the case moves into legal channels, when instead they're met with a calm, precise, legally sound message. Many simply back off because they know they have no legitimate justification to put in writing. That contrast makes all the difference. An argument at the door disappears into thin air, leaving no trace, and becomes just one person's word against another's. A text message or email, on the other hand, stays on record, can be shown to a lawyer, a mediator, or a judge, and builds, from the very first moment, a sequence of facts that favors whoever acted with calm and intelligence, not whoever lost control. Beyond sending the right message, there's a next step that many tenants overlook, but one that can be exactly what decides the outcome of the entire dispute. After making the formal request for access and written justification, it's essential to document every detail of that moment, because no court or mediator will simply take someone's word for it weeks or months later, based on memory alone. The first step is to photograph the new lock, ideally also showing the door, the apartment number, or the visible address, to clearly prove where and when it happened. It's also worth writing down the exact time the person realized they could no longer get in, since that information, combined with the message sent to the landlord, creates a precise timeline of events. Another essential point is to keep every single message exchanged with the landlord, whether by text, email, or messaging apps. Never delete conversations, even if the landlord's tone seems aggressive or disrespectful, because those messages, however uncomfortable, also work in favor of whoever is trying to prove they acted correctly, while the other side refused to cooperate. Whenever possible, the tenant should insist that any response from the landlord come in writing, avoiding as much as possible agreements made only verbally or over the phone. A promise made over the phone doesn't carry the same weight as a text message or an email, because without a record, everything, again, comes down to one person's word against the other's. If the landlord calls, the best move is to respond in writing right afterward, confirming what was discussed, thereby creating a new record of that conversation. In the end, in disputes involving landlords or even foreclosure proceedings, whoever can clearly reconstruct the exact sequence of events with dates, messages, and concrete evidence generally ends up in a much stronger position under the law. Calm and organization, more than any shout of outrage, are what truly protects someone when the issue is their own home. Situations like this show why knowing your rights as a tenant can be the difference between coming out a loser and coming out protected. The law is on your side, but it only works in your favor when you know how to use it. If this video helped you better understand this topic, like it and subscribe to the channel to keep learning how to protect yourself from abusive landlords, banks, and HOAs in the United States.